We will hear oral arguments in case number 18CA0072M entitled The State of Ohio versus David Gonzalez. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Let me know if you plan on reserving time, and I'll let you know when you get close. These arguments are also being recorded, so please remain at the podium and keep your voice up so that not only the court but the video can hear you well. The court has read the briefs in this matter, and we are ready to proceed if you are.
May it please the court, Mr. Beglucci, I'm Attorney Joseph Salzgeber, and I represent the defendant appellant David Gonzalez in this matter. This matter involves a consensual or allegedly consensual encounter between a police officer well outside his own jurisdiction and my client and the other occupants of a motor vehicle in which he was a passenger. I think that probably the best summary of my argument can be set forth in my rather lengthy assignment of error. I am, on behalf of my client, arguing that the trial court committed reversible error by denying my client's motion to suppress the evidence based on a violation of his rights under the Ohio Constitution, specifically Article 1, Section 14 of the Ohio Constitution, where contrary to the relevant statutes, Ohio Revised Code Section 293503 and RC 451339, the Medina Township police officer was outside his township's territorial jurisdiction when he approached a parked motor vehicle in which my client was a passenger. The second component of our argument is that the township officer did not observe and was not aware of any traffic violations or other suspected illegal activities by the vehicle's owners or occupants that took place in his own jurisdiction in Montville Township.
Counsel, are you going to reserve time for rebuttal?
Yes, I'll reserve the balance of the time.
We have up to 5 minutes.
The third component of the argument is the motor vehicle in which my client was a passenger was not located within an adjacent jurisdiction or neighboring jurisdiction of the township officer's township, which is Montville Township. And finally, the fourth component of the argument is that the township officer's commission as a reserve sheriff's deputy in Medina County did not authorize him to investigate suspected illegal drug offenses outside his own township and to detain the suspects. I know your honors are familiar with the facts. This matter involved Officer Gibbons and another officer, Deputy King, who were engaged in what they call cold case drug interdiction efforts. Officer Gibbons was in his own Montville Police patrol car wearing his own Montville Police uniform when he was engaged in this task. He observed the vehicle in which my client was a passenger driven by a Damien Ziff. He saw that vehicle traveling on I-76 headed east. He thought that it was odd that the vehicle had a Trumbull County license plate when he ran the license plate. Why he thought that was odd is not explained because that is an Ohio license plate.
Does he need to give a reason to follow Mr. Gonzalez?
No, he's free to follow the vehicle, but he had really no reason to do that. Officers will typically run the plates which are visible on the back and front of the vehicle. In running the plate of Mr. Ziff in his vehicle, he found that there were no warrants. Mr. Ziff had valid driving privileges. His plates were not expired, but based on an inarticulable hunch, the officer continued to follow the vehicle as it got off the highway and onto State Route 57.
Was the area on 76 right there? So was any of that area in Montville Township or was it completely out of his Montville Township?
I believe a section of that does run through the township. Some of it does. But he proceeded to follow that vehicle driven by Mr. Ziff outside of Montville Township into Wadsworth Township, which is a neighboring jurisdiction, and then furthermore into the city of Wadsworth, which is 2 jurisdictions away. So he was not in an adjacent jurisdiction when he saw that vehicle stop and park in the parking lot of a business called the Roar Corporation within the city of Wadsworth. He got out of his vehicle and approached the parked vehicle in the city of Wadsworth, and he indicated that he observed puncture wounds in the arm of my client when he encountered the vehicle. This is where he indicated that they were not free to leave. That did not, and unfortunately, the trial court, despite that appearing in the record, did not include that in its description and summary of the stop or encounter in its own entry. But it is in the record.
Counsel, there was some, albeit brief, some conversation prior to that observance of the puncture that the state's relying on to make their consensual encounter, correct?
Correct. The vehicle.
Discussion?
Yes, the vehicle, police are allowed to approach people on the street, parked vehicles. This was not a traffic stop, quote unquote. Our argument is that this Officer Gibbons did this 2 jurisdictions away. This was not in Montville Township at a shopping center where he just walked up and said hi to someone in a parking lot or in a building or on the street. He actually followed this vehicle while on duty in his marked patrol car and in his uniform, multiple jurisdictions away, and the Ohio Constitution and the relevant statutes, we argued, that did not permit him to do that.
If he was working as part of his assignment to the Medina County Drug Task Force at the time, would that affect your argument?
Yes, that's sort of the linchpin, and that's the fourth aspect of the argument. The state of Ohio is claiming that because he is a reserve deputy and was working with the task force under his reserve deputy authorization through the Medina County Sheriff's Office, that gave him the authority to do what he did, and it would give him countywide jurisdiction in Medina County. However, when you look at the actual written document, that does not support the state's position. In this particular case, we had an inarticulable hunch. The officer testified this was a completely cold stop. There were no tips or anything like that. There was no observation by the officer of any illegal activity, not even crossing the center line, running a red light, failure to stop. There was no traffic violations observed. The only justification the officer gave was that Trumbull County is awfully far away, which is subject to interpretation because Trumbull County is about 2 counties away from where the stop was made. I'm making the argument under Article 1, Section 14 of the Ohio Constitution rather than the Fourth Amendment, which people are more familiar with. Article 1, Section 14 is the Ohio Constitution's analogous provision to the Fourth Amendment to the United States Constitution. And in 2015, the Ohio Supreme Court specifically stated in State v. Brown that Article 1, Section 14 of the Ohio Constitution affords greater protection than the Fourth Amendment does against searches and seizures conducted by members of law enforcement who lack authority to make an arrest. Therefore, a traffic stop for a minor misdemeanor offense made by a township police officer without statutory authority to do so violates that provision of the Ohio Constitution. The court went on to say the government's interest in permitting an officer without statutory jurisdiction or authority to make a traffic stop for a minor misdemeanor offense in such circumstances is minimal and is outweighed by the intrusion upon the individual's liberty and privacy which necessarily arises out of that stop. Now, there's been very little law since 2015 because of that recent opinion, but State v. Brown, we argue, controls in this particular case. Because when you look at the statutes, the relevant statutes I mentioned, 293503, that is the statute that deals with the officer's authority to make warrantless arrests, and it limits that to the geographical boundaries of the entity or political subdivision that employs the officer, in this case, Montville Township. The The other statute that's relevant is 45-1339, which concerns the power to make arrests on highways, and that contains various limitations on the abilities of township officers to make arrests on highways. In particular, if it's either got to be within their jurisdiction, they've got to observe a violation or illegal activity within their jurisdiction of the vehicle because it's moving travels outside the jurisdiction. So that's the second possibility. That didn't happen because the officer said he observed no illegal activity or traffic violations. The vehicle was not in an adjacent or bordering jurisdiction. The officer could have gone into an adjacent or bordering jurisdiction because many roads run through multiple jurisdictions. The city of Wadsworth is 2 jurisdictions away, so it's not a bordering jurisdiction. And finally, what the state is primarily relying on is that the commission of the officer as a reserve sheriff's deputy did not somehow authorize him, but if you look at the actual commission, it does not authorize Officer Gibbons of the Montville Township Police Department to do what he did. And I will quote the language here. And this is a written document. The reserve deputy authorization is a written document provided and signed by the Medina County Sheriff. It was attached as Exhibit 1 to Mr. Gonzalez's motion to suppress, and it expressly states this reserve deputy commission is only valid for purposes of the attack response, training, or related emergency response as defined in the motion or the memorandum of understanding for regional SWAT team between the Sheriff of Medina County, Ohio, and Medina County, Ohio townships and municipalities.
Counsel, did anyone make the memorandum of understanding a part of the record of the trial court?
It was, Your Honor, it was filed with the trial court as an exhibit attached to the motion to suppress.
Thank you.
And that sort of brings me to another case. The state of Ohio had a somewhat similar case out of Medina County, and I'm not sure if Mr. Delucci argued that himself or not. There was a case before this court called State v. Lentine. That was a case from 2016, which is factually distinguishable from this case. In that particular case, the defendant and his attorney did not introduce a copy or any evidence of the reserve deputy appointment and commission document as took place in this case, which by its terms expressly limits the duties of reserve sheriff's deputies. And in the Lentine case, the township officer actually observed a marked lanes violation on the highway. So there was not merely a consensual encounter, as is alleged in this case. So there was reasonable suspicion of probable cause in the Lentine case, and there was no evidence, which was the burden of the defense, to demonstrate that there was a lack of authority. In this case, we have just the opposite. We have no observation of any illegal activity. The officer, Gibbons, ran the license plate. There were no warrants. There was no lack of driving privileges, no suspended license plate.
You're at 2 minutes, just to let you know, total time.
So in summary, Your Honors, based on the fact that Officer Gibbons did not have statutory authority in which to conduct this encounter and eventual arrest of my client and one of the other parties in the car, because he lacked that authority, and he was 2 counties away. State v. Brown and the Ohio Constitution dictate that the evidence should have been suppressed in this case, evidence that was seized, including statements made by my client, drugs found in the vehicle, and any observations made by the officer. All that should have been suppressed by the trial court, and they erred in doing so. So we're asking this court to reverse this matter and remand back to the trial court in Medina County with instructions to grant that motion to suppress and exclude that evidence at any retrial. I would reserve the balance of my time. Thank you.
And that would be 1 minute.
Honors, and may it please the Court, I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. In terms of Officer Gibbons' authority to investigate, he works for the Bonneville Township Police Department, that's true, but in 2015, he was appointed as a reserve Medina County Sheriff's deputy. And one purpose of that appointment was to allow Officer Gibbons to serve on a county-wide, what's called a criminal patrol task force. Now, he serves on a couple other task forces as well. I think he is involved in the drug task force as well, and I think an OVI task force he testified about. But on this particular day, on May 16th of 2017, where he encountered Mr. Gonzalez, he was serving on the Criminal Patrol Task Force, whose job actually is also to deal with drug issues. That is its stated purpose. I included that in my brief. It's public record in terms of what that's for. They announced it when it was first formed to do drug interdiction in response to Ohio's drug crisis, essentially.
Does our record support that? Was there testimony from Officer Gibbons that he was engaged in a tactical response as part of the Medina task force or in an emergency as part of the task force?
He stated that he was involved in drug interdiction as part of the Criminal Patrol Task Force. That's what he was doing then.
Counsel, how does drug interdiction, and I understand the importance of it, how does that fit into, for the purpose of a tactical response, training, or related emergency response?
Well, I'll first say I agree that the commission document that Mr. Salzgeber was referencing, that is in the record. That was attached as an exhibit to Mr. Gonzalez's motion to suppress. That was not our exhibit, that was his exhibit. He actually attached it to his motion to suppress. And it does include this disclaimer that he read, that's on the face of it. But I disagree that the MOU that it references is actually in the record. I think that document is in the record. It talks about this MOU. And it says, in fact, that it's further defined in the MOU. That this phrase, tactical response training or related emergency response, is further defined in the MOU. But we don't have the actual MOU between the township and the sheriff's department in the record. But we know that there's a more detailed description of what that means somewhere. It's just not in the record.
Would it have been the state's burden to put it in the record?
I don't believe so. I believe we have and I think the fact that the commission document is actually in the record in this case, Mr. Salzgeber was distinguishing that from the Lentine case. I think that actually makes this a stronger case for the state. We actually, instead of just having him testify that he has a commission, we actually have the document itself making him a reserve sheriff's deputy. Now, I think you have to presume, I think what Mr. Gonzalez's argument is asking this court to do is to presume that this MOU does not contemplate that that Officer Gonzalez serve on this criminal patrol task force when there's no evidence to that effect. In fact, I don't think it's a very big leap to say that this is a tactical response or an emergency response to the drug crisis, as I was saying.
So you're telling me that what's in the record is the actual commission that says Detective Gibbons is part of this group?
It does not say that he's part of the Criminal Patrol Task Force. It says that he is a reserve, it makes him a reserve sheriff's deputy.
Okay, but that's not what the actual memorandum of understanding, that's not the actual memorandum, that's just something that says he's a part of that.
Correct.
So we don't have the scope of what the actual group is allowed to do in the record.
I don't believe so.
So when in appellant's brief says that there was no testimony at the suppression hearing that he was engaged or participating as a reserve sheriff's deputy. There was no testimony at the suppression hearing that he was engaged or participating in the tactical response. There was no testimony of any of that stuff. Is that correct?
He didn't use those specific words that we have on his commission document. He didn't say that, but he said he was operating he was doing drug interdiction for the Criminal Control Task Force.
But your position is that that's not that document, that was Exhibit 1 is. It's not the document, it's the memorandum, it's a different document that wasn't admitted.
That's referenced, right, that's referenced in the commission document. Yes, and it says MOU, we're even presuming, I think, that means a memorandum of understanding. It just says MOU actually on the, I guess, it almost looks like a stamp that they put on all of these. It almost looks like it's just something they, just as a matter of course, put on every commission, this language, and it's referencing this language that says it's more detailed language somewhere else. But I don't think we have that more detailed language, and frankly, it wouldn't make much sense if the MOU didn't contemplate the very thing that it was entered into for, which was to have this countywide task force. I think without any evidence, Mr. Gonzalez is asking this court to presume the opposite, that this MOU did not contemplate this.
So you included in your brief excerpt from the website for the Ohio Task Force Commanders Association. Is that in your record other than in your brief?
No, it's not. But I think that's public record. That's something out there that this court can consider. Just because that particular article wasn't introduced into the record, I think that's something any person can take notice of, and this court can take notice of. That this is not something anybody was trying to hide. Everybody knew this was what the purpose was at the time. It was pretty well publicized at the time, and it gives you some insight into what exactly it is. But in terms of, I'll get back to the Lentine case, because I think that's very important. I think that's controlled precedent for this court. Decided just in 2017, and in fact, it considered this same issue essentially. It involved this same officer working on this same task force, actually. It was Officer Gibbons again. The question there was, did Officer Gibbons have the authority to make a traffic stop outside of Montville Township as a reserve deputy working on this task force while in a Montville uniform and a Montville cruiser? So the only difference there is that you have traffic stop. In this case, it was I think I heard Mr. Sulzgeber concede a consensual encounter initially, which eventually turned into a Terry stop, an investigatory detention, and ultimately an arrest in a parking lot. But, so that's the only difference there, and I don't think
Correct me if I'm wrong. Did Officer Gibbons in the Lentine case testify that at the time he was working as part of the task force? I'm not so sure that testimony is present in the case that's being argued today. Is that a distinction? Is it a distinction of significance?
I think he did argue, or I'm sorry, he did testify in this case that he was arguing that he was working for the Criminal Control Task Force. I do believe that is in the record, and as well as in Lentine. And I agree with you. I think it would be a problem if he didn't say that, because that's what gives him his authority to do what he did here, follow this vehicle outside of his territorial jurisdiction, engage in outside of his Montville jurisdiction, I should say. He was within his territorial jurisdiction by working on this task force, and that's why I don't think any of these statutes that Mr. Sulzgeber mentioned apply here. This 29-3503, 45-13-39, those statutes don't apply because, well, first of all, he wasn't outside of his territorial jurisdiction. He was working on a countywide task force. And so in Lentine, and I'll quote, this court actually held, the defendant has not provided this court with any authority to suggest that a sheriff's deputy cannot perform his duties unless he is wearing a uniform and using equipment that were provided by the sheriff's department. And in fact, there is no authority that says that. Essentially, the argument is that for Officer Gibbons to have countywide authority, he had to strictly comply with all of the uniform and car marking requirements in the Ohio Administrative Code. But certainly, I think implicit, at least in this court's decision in Lentine, is the idea that a sheriff's deputy is not going to be stripped of his otherwise valid authority just because his uniform doesn't comply exactly with the OAC. As the trial court, I think, correctly noted, for this court to hold any other way would be a very dangerous, slippery slope, sort of a Pandora's box that would open the door to all kinds of very technical questions about the uniform of a sheriff. But that's not the point of those OAC sections. It's really just to promote uniformity among all of the sheriff's departments of the state of Ohio. But the detail that the OAC goes into in terms of a sheriff's uniform is pretty remarkable. It goes right down to types of fabrics, designs, and even thread counts. And all of those subsections use the word shall. And they don't distinguish what requirements are more important than others. They all say shall, even down to the slightest detail. And if this court's going to accept the argument that Officer Gibbons' uniform should trigger the exclusionary rule, which is what they're essentially saying in a motion to suppress, then again, I think it's a very slippery slope down. Even the slightest deviation from the OAC could potentially trigger it. I don't think it makes sense to go down that path. This court refused to do that in Lentine, and I think should continue not to entertain that, go down that path. But like I said, I'm not sure why this court would presume, based on really no evidence, that the MOU that's referenced doesn't contemplate the very thing that it was for, that Officer Gibbons testified it was for. And I don't believe the actual stop itself is being contested today, but I think there's no question that the initial encounter was a consensual encounter, that there was some argument, I believe in the brief, about that. I think a reasonable person in Mr. Gonzalez's situation would have felt free to leave, at least initially. Officer Gibbons did not turn his overhead lights on. He did not block in Mr. Zeif's vehicle in any way from either leaving its parking spot or from leaving the parking lot. Officer Gibbons was not speaking or acting in a threatening manner whatsoever. Like was mentioned, he was discussing with them their tattoos. Mr. Gonzalez and another passenger had some tattoos as well on Miss Greenman, I believe, and that's when he noticed puncture needle marks on Miss Greenman's neck and on Mr. Gonzalez's arm as he's looking at these tattoos.
If at that time those two folks decided that they're going to get out of the car with Mr. Zeif, would they have felt free to get out of the car with Mr. Zeif at that time? Before
the needle, the puncture marks were seen at the outset, and just as Officer Gibbons was walking up to the car.
Even if he sees the marks and there's blood on it, could she have just said, "Hey, I need to go and use the restroom," and on them they use the restroom?
If at that time he had seen the needle puncture marks, probably not, because if he had not seen them yet, if he's far away enough to where he's not having that conversation, he doesn't see them, because that's what gave him the reasonable suspicion that made this turn from a consensual encounter into an investigatory detention. That's the moment when it became a Terry stop. So that's the moment they were not free to leave, was when he observed that. And granted, that was not a very long period of time. It was described as, I think, moments. Mr. Zeif was already outside of his car as Officer Gibbons was approaching. Mr. Gonzalez and the other passenger were still in the vehicle. He's initially speaking with Mr. Zeif, and then he starts very shortly speaking with Mr. Gonzalez as well, and they're talking very casually about tattoos, and that's when he happens to notice those puncture marks, which his training and experience told him is indicative of illegal narcotics use, as he testified. So that's when, and he still hasn't even asked for their IDs at that point, until he observes those puncture marks. Then he asks for the IDs, which he didn't need reasonable suspicion to do that regardless, but he does, and when he gets those, and he runs the other passenger, Miss Freeman, and that's when he sees that she has a felony 2 warrant out of Sutton County, and so that's what she's detained, and that's when the dog is called for the sniff.
And counsel, your time is up.
Thank you, Your Honor.
Your Honor, I know I have 1 minute, so I'll have to speak very quickly here. The reserved Medina County Sheriff's Deputy Commission document did not authorize what Officer Gibbons did. It had been a City of Wadsworth police officer or a regular sheriff's deputy under normal commission. That person could have done what was done by Officer Gibbons, but Officer Gibbons lacked the direct authority to do that. This was not a SWAT team mission. We were not engaged in a tactical response, training, or other related emergency. There was no testimony to that effect. In fact, Officer Gibbons says these were completely cold stops, no tips, and the only reason he followed this vehicle was that Trumbull County, Ohio, which was the license plate of the vehicle, was awfully far away. And there was no observed criminal or traffic violations. And it is, in fact, the state's burden when the defendant raises with some sufficiency an alleged constitutional violation. It's the state's burden, not the defense's burden, to demonstrate that there was no such violation.
1 minute goes fast.
Right, defense counsel in this case attached the...
And your time is up, so you'll have to wrap up.
Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail you a copy of the court's decision on the day it is released, and the opinions are also posted on the Supreme Court of Ohio's website, so you can check there.